I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame. And you guessed it, today we are on another compilation, and this compilation will be 236. For this compilation, we will be in 3 different judges' courtrooms. Before I give you their names, don't forget to like, comment, share, and subscribe. Also, commentary will be left in these proceedings for this compilation, and chapters will be added for your convenience. Now, the first courtroom we will be in is that of Judge Guerrant out of the state of Georgia. Second, we will be in the courtroom of Judge Michael Olsaver out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Marlena Taylor, also out of the state of Michigan. I hope that you guys are enjoying these compilations the same way I'm enjoying putting them out. So without further ado, it is time to jump in to 236.
Miss Ellis, you could come into the camera for me.
I'm here by special appearance judge as a legal.
Hold on one second. So Miss Ellis, I just need to swear you in first and then you can make your statement. If you could please raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I stand in honor and affirm that my words shall be truthful with full reservation of my rights under God's laws and natural law.
Okay, you can put your hand down now. Thank you. All right. So I have already reviewed the case. I remember Miss Ellis from previous dispossessory where there was, long story short, that the parties, at least at that time, did agree that she had taken subject to a valid lease. And that they had not asked, they had not pled for non-payment, and I'm assuming this is where this new dispossessory is based on the non-payment, based on the lease that she had with the previous owner. Is that correct, Mr. Thor?
That is correct, Your Honor.
Okay, and it looks like so, Ms. Ellis, I looked that you did file a late answer in this case. I saw that you had said you had emailed your answer or some sort of response to the plaintiff. That does not count as an official answer. So it actually, your answer does have to be uploaded into the file within the 7-day time frame. So it is a late answer. I did also just review it. I didn't see any legal defenses or counterclaims in this. So this would technically today be a judgment on the pleadings. So Mr. Thorpe, if you'd like to present your case.
Yes, Your Honor. So this was filed for non-payment of rent. Service was effected on December 10th. No answer was filed. Defendant is in default. We request a immediate writ of possession.
Okay, with the judgment on the pleadings, it would be 7 days from today. So that would be the 5th of February. Since you, well, technically,
that'll yeah.
It was a late answer. You are right.
May I, Judge?
Yeah, just 1 second. I'm just getting his case first, and then I'll come to you. Let's see. Yeah. Okay. So based on the answer being filed late, so you're just seeking the writ. You don't want the answer accepted, so you're just seeking the writ.
Correct, Your Honor.
Okay. Okay. So, Ms. Ellis, before you make your statement, I just want to make just a general statement about the fact about the answer being late. Okay, so here are the pros and cons. You filed a late answer. Like I said, there wasn't any legal defenses or counterclaims in the answer that you did file, but you did file a late answer. If you want me to accept that answer, that would subject you to being subject to a money judgment in the case. However, it would give you an additional 7 days before the plaintiff could file for a writ of possession. If your late answer, if you choose to have me not accept your late answer, then the writ would be available for them to apply for as early as today, but you would not be subject to any form of money judgment that they could use to collect on. But you would have to, the writ would be available to them a little bit 7 days earlier than it normally would have been. So I guess my first question, so I guess if you'd like to make your statement, but then I'm going to need to know whether or not you want me to accept your late answer, because if you want me to accept your late answer, there would probably be a money judgment associated with your order. but the writ would be applied for in 7 days. If you do not want me to accept your late answer, it would just be a writ available today or whenever they filed for it already, I believe. The writ would be signed today, but there would not be a money judgment against you. All right, so if you'd like to make your statement now.
So under what authority is the abatement that I filed could not be the answer? Because is it ethical for the court not to accept the abatement that I filed, because that's how I usually filed, and it was always never a problem?
Filed. There's nothing filed.
So I have that evidence because I went into the court and they showed me that was filed, and they said to me, that's what you were stating this court case on. So I want that answer to be put in place as the answer for that abatement.
If you file the late answer, like I said, it would subject you to a money judgment. I'm not sure what you mean in terms of an abatement, but the rules for dispossessories are pretty simple. If you have not paid your rent, they will file based on non-payment of rent. They'll issue a demand. And then if you do, and essentially, unless you can show that you've got some sort of legal defense,
I do.
The dispossessory itself, and what would that be?
I do have legal defense. First, I want to repent for all my debts, and I like to rescind my prior actions to start over. Evidence that I filed a case. I filed to buy the premises from the real party of interest. That's why I was asking this attorney if he does have evidence of who's the real party of interest on this property. Because even yesterday, I was speaking with the owner of the property, telling me that I need to send in a GAR and my proof of funds. So this is not about possession or monetary value, because I have all that evidence.
So Ms. Ellis, in the previous case, it was shown that this plaintiff purchased the property at foreclosure. You had a lease with the former owner, and like I said, there's nothing along those lines. Hold on one second.
I do have that evidence, Judge, because we never get to that situation because of all the situations that were happening. I do have all that evidence.
That's do you want me to accept it? Ma'am, do you want me to accept your answer or no?
Yeah, I want you to accept my answer so I can move forward.
All right, I will accept your late answer. That does mean, Mr. Thorne, that the writ would be available in 7 days, but you can seek a money judgment. Ms. Ellis, you can make whatever argument. I've read through everything you filed in the case. It does not present any sort of legal defense to this dispossessory proceeding. All right, so Mr. Thorne, she does want her answer accepted. So if you'd like to present evidence on the rent owed, you can do that if you'd like.
I believe you have a copy of the lease agreement, Your Honor. Monthly rent is $23.50 with a $30 late fee. Rent has not been paid since October. It was found, I guess, in the prior case handled by the prior counsel that rent had been paid through September. So October, November, December, and January, and late fees would be $9,520.
Okay, you said it was $2,350 per month?
Correct.
And then that would be...
And a $30 late fee.
So you're not seeking... Okay, so you're just seeking through January?
Yes, Your Honor.
And may I ask a question, Judge, if that's okay?
Just 1 second. Just 1 second.
Okay,
yeah.
Thank you.
1, 2, 3, 4. Okay. So I did. So that's 4 months, October, November, December, and January at $23.50 per month, plus $120 and $30 late fees per month. That amount is $9,520. All right, Ms. Ellis, what would you like to say?
So I just need to ask the question. So if the payment is not received while I'm negotiating with the owner to buy the property, you said in 7 days, what's the next step?
Well, they're not required to accept any if they choose to accept payment from you, that would cancel the writ in this case. So if you come to them and you guys are able to work something out and they agree to accept funds from you, that would cancel the writ of possession in this case. But again, that's something you'd have to reach out to Mr. Thorne to talk about. But again, like I said, if they did accept, the triggering thing is them accept. if they accept it, if they accept the funds, if you send in funds and they accept it, that would mean they would have to cancel the writ. But otherwise, the writ would be in place.
So what is being done today? You're filing a writ for possession in 7 days. Is that what you're doing?
Okay. The landlord will be able to, because I'm accepting your late answer per your request. The landlord is seeking a money judgment in the amount of $9,520. And then they will be able to apply for writ of possession by 11:59 p.m. on next Wednesday, which is the 5th of February.
So that will be a new case or the same case?
This is this case, ma'am. This is the order in this case.
So will I be back in court or not?
This case is going to be over as of today. This will be a final order in the case. I will enter that order, and then the writ will be available to them to apply for at 11:59 p.m. on the 5th of February.
So is this a default judgment that is going to be closing out today, you're saying?
This is not a default judgment. It's a judgment on the pleadings. You didn't present any legal defenses. I'm accepting your answer, but there are no legal defenses or counterclaims regarding this dispossessory. So they're going forward today just on the pleadings. Based on the pleadings, the amount owed is $9,520. And like I said, one more time, the writ will be available at 11:59 p.m. next Wednesday, which is February 5th.
Thank you.
All right. So that'll be the order of the court. Mr. Thorne, I will prepare that order. Okay.
Thank you, Your Honor. I appreciate it.
Thank you. Have a good day, sir. You're both free to go.
People of the State of Michigan versus Donald Raymond Guerrant Lester. We are here today for a final pretrial conference in this case ahead of a trial scheduled for June 20th and 21st. We are proceeding today partially in person and partially by video conference. First, let me have the attorneys place their appearances on the record, beginning with Ms. McClure.
E.B. McClure filling in for prosecutor of record Isaac Sneed.
Samir Hennigan on behalf of Donald Lester.
All right, and Mr. Lester, I believe, is in the jail Zoom 2 device. Mr. Lester, are you there?
Yeah, I'm here.
All right, so I don't know what's going on with the camera. We can't see you. It looks to be shooting
I can see you.
Almost. I'm saying that we can't see you, Mr. Lester. So, Ms. Hennigan, where do we stand? Are we ready to proceed to trial on June 20th?
Thank you, Your Honor. I met with my client yesterday and did make the final offer to him with regard to plea agreements. My client has declined to accept the plea that was offered by prosecution. I also was informed by my client that he has filed a few motions. I guess you would say pro se. I have not seen those motions myself, but he says he mailed them to the court. He does have many objections to the proceedings. That being said, the next step that would be appropriate with regard to our legal procedures would be to go forward with trial. I am prepared to do that, though I do believe that my client will object to that, Your Honor. So I do want to make sure that I represent his wishes as well, while I still inform the court of whether or not I'm ready to proceed. So I will be ready to proceed for trial next week. That being said, my client does not want to go to trial as he feels that the court doesn't have jurisdiction over him on this matter in order for us to move to trial. And he was very upset. I would add, just for the record, for his for appellate purposes for him, that he was upset that I agreed to a trial schedule at a past hearing. And I did try to explain to him that that's just a procedure, that the court is on timeframes according to statute, and that at some point we do have to set a trial schedule, even though it was my intent to continue to try to negotiate this case for him along the way.
All right, to the extent that there's any objection based on court's jurisdiction,
I can't hear you. Can you speak up, please?
To the extent that there's any objection to proceeding to trial based on the court's jurisdiction, I would deny that, as the court does have jurisdiction over this case. It is a felony case involving an alleged felony which is alleged to have occurred within Lenawee County, state of Michigan. This is the circuit court for the Lenawee County, state of Michigan, and therefore jurisdiction is appropriate. Ms. McClure, is there anything we need to address from the people's side?
The people have not received any motions that have been referenced, but as far as I know, we are prepared to proceed to trial next week as well.
Right.
All right, so do we have proposed jury instructions and voir dire questions yet?
We do not, and I spoke with Mr. Sneed yesterday, but I'm certain that we can agree upon those within the next day or so.
I see some in our file, so maybe he's drafted them and just not.
Yes, he was working on them.
Okay, so I'll need those by the end of the week so that we have an adequate amount of time to get prepared for trial.
I would also like to intervene here real quick, but that being said, the motion is just not for the jurisdiction, it's also for personal jurisdiction and subject matter jurisdiction. I had the right to a resisting unlawful arrest, and it's not being addressed. The Supreme Court ruling on that, I just read that not too long ago, and they arrested me for an old traffic ticket, is where it started at. They're trying to dodge the point of where they harassed me for 3 days before they arrested. And as far as this possession situation go, I was informed yesterday by my attorney, who I haven't talked to since March, that I was looking at 14 years. Under your court, Michigan rules that after 10 years, under a lower felony, after 10 years, it's automatically expunged. So I'm trying to figure out how am I being charged with a habitual criminal. And also, I would like to get that in writing that you said that you have jurisdiction over this case, but not the said person. And that's all in the motions that I sent over to the clerk's office. I also have them all notarized. I also have copies of everything that I sent over there. So there should be somewhere in y'all file that y'all should have it.
Your Honor, I did.
And personal. And like I said, I haven't talked to this woman since March. She told me that I was going to be released out for bond, and I haven't heard anything from her since then. I wrote her a letter. The first time I seen this woman in about 2 or 3 months, his first time was yesterday. And she doesn't represent the said name anyway. I've talked to her about that situation too. Somebody's not being truthful here. And I've been sitting here almost 10 months without a bond or even so much as calling my witnesses. She's never asked me anything. So my due process is being violated. Also, I'm sitting in here on an unsigned warrant. Unsigned. A probable cause warrant. They trying to make it look like they arrested me for those charges, and it's not what it was for. That's not what it was for. I was arrested for driving on a suspended license from back in 2016. That case got dismissed.
Your Honor, I did inform him
He's not
yesterday.
addressing none of those issues, Your Honor. Period.
Mr. Lester, I need you to stop interrupting people, okay? What is it that you wanted to say?
I did inform him yesterday that the charges he was facing could, that it's up to 14 years because there's consecutive sentencing available on those charges. He has a felony that is up to 10 years and then 2 R&Os which can be sentenced consecutively if that were requested and or if the court were to do it. And I informed him of that at the time that I was telling him about the plea agreement that would allow him to be released today. So he is correct in that I did inform him of that, but it's not because of a habitual offender notice. And he asked me about that yesterday, and I reiterated again yesterday that that is not why. That is not why he's facing that amount of time. It was simply me telling worst case scenario in this matter.
All right, so to the extent that personal jurisdiction issue has been raised in addition to subject matter jurisdiction, and again, deny any request on those bases because the court, again, has personal jurisdiction over Mr. Lester, who is a human being located in Lenawee County, Michigan, and alleged to have commit a felony crime in Lenawee County, Michigan.
How did I commit a violent crime?
With respect to the argument that Mr. Lester made regarding the right to resist an unlawful arrest, that's why the court is having a trial. One of the elements that the prosecutor needs to prove in a resisting and obstructing case is that the officers were on duty, acting lawfully, and made a lawful arrest that Mr. Lester resisted. So that's the purpose of the trial. With respect to any issue about expunged convictions, we're not even to that point yet. The habitual offender issue comes into play only after a conviction has entered, and then the court has to determine whether the convictions listed in the habitual offender notice in fact happen and can appropriately be used under the statute for the sentencing enhancements that have been notified in the information. And so
okay, so whenever you get done, I'd like to address the issue too, please.
All right, I'm going to mute Mr. Lester because I can't have people talking over me while I'm trying to create a record. All right, so then we are ready to proceed to trial on June 20th. Again, I'd like to have the voir dire questions and jury instructions ready or to the court by the end of the week so that we can have those ready to go.
Thank you, Your Honor.
Yeah. Before we go,
Ms. McClure, can I just understand from you what that final offer you made on this case, or what the final offer the prosecution made on this case was?
Yes, it would be.
Ms. McClure, I actually have a copy that I could pass to the court too, if that's okay with you.
Yeah, I mean, we'll just take a second. It's an added count for possession of meth in a park, which is a 2-year offense. And we were offering credit for time served, which is approximately 10 months. And we have no objection to a PR bond at the time the plea is taken.
Ms. McClure, could I just add that Mr. Sneed did inform me that you had authority to do fines and cost only on this as well? No. That be accurate?
I think that would be part of the credit for time served.
Thank you.
So the prosecution has made an offer to resolve the case if Mr. Lester were willing to plead guilty to possession of methamphetamine in a park. That's a 2-year maximum possible penalty, but the prosecution has also agreed to credit for time served or fines and costs and a personal recognizance bond release until the date of the sentencing. Is that all accurate, Ms. McClure?
How is that? That is crazy.
Yes, that's accurate, Your Honor.
And Mr. Lester is not interested in agreeing to that plea. Is that correct?
It's my understanding, but it seems that he would like to say something about it, Your Honor, so I prefer that he answer that question himself.
Yeah, I would like to say something because of the fact that you keep trying to let me out on a PR bond and you want me to come back to court for sentencing, but you won't let me out to try to get my witnesses and gather the evidence that I need to be able to present it at trial. I haven't even went over this one. I haven't even went over any kind of defense with this woman. I am being prosecuted and persecuted by her and a prosecutor. And it's obvious. It's very obvious. It stands out. I haven't talked to this lady since March. And when I did, she came in there and coerced me into trying to keep her on my case.
All right, so Mr. Lester, that wasn't really responsive to the question that was asked. The question you're being asked.
I don't know nothing about that. I told her what it was then, and
Mr. Lester,
you keep trying to cut me off.
Well, that's because you won't let me create the record and do my job. So I'm
trying to do my job. You're not the one sitting in jail, sir.
All right. So, Miss.
Your Honor, would you
All right,
please
so
mute my client? I don't want him to.
Record should reflect that. The record should reflect that Mr. Lester had. I'm sorry. So, Mr. Lester, the question I'm asking and that I need an answer to is you've heard the offer that I've indicated the prosecution has made to you to resolve the case. Do you or do you not want to?
No, I'm not, because they had no business arresting me, Your Honor. And I wasn't bothering anybody.
A simple no is fine. That's all I needed. All I needed was no.
Quit talking to me like I'm a kid.
The answer is no, so we will proceed to trial next week. I don't think there's anything else we need to address this morning. So
Bond. I need a bond.
That you are done with court.
See what I'm saying?
All right. Ms. Hennigan, are you ready to proceed?
Hello, sir.
How you doing?
I'm good, thank you. What's your name, sir?
Your Honor, if I can help you.
I'm Williams L.
Yes, Your Honor, but the defendant is identified in the docket as Michael Williams. Is that correct, sir?
Yes, that's the name they're calling me, but okay. I am Williams L.
I understand.
Michael Williams, okay.
No, I'm not Michael Williams, Your Honor. Okay. I am Williams L.
Okay, so here's the thing, Williams L. I have to call you what's on the documents that I have present for me in court today. We can either handle it that way, or you don't have to handle it, and then it just will be like you didn't show up to court today.
No, so Your Honor, I'm just letting you know who I. Your Honor, I'm just letting you know who I am.
Okay.
I am Williams L. I am not Michael Williams. They kept calling me Michael Williams. I told them who I was. I am a sovereign, Moorish American. I'm not United States citizen, Negro, Black, or color, Your Honor.
Okay, so let me tell you, Mr. Williams, this is the last time I'm gonna say it. This is all I have for you. If you don't want to handle it under that name today, then I have to act as if you aren't present. And so that's fine, but I
You
have
say
to
what? Hold on. Can you repeat that? Can you repeat that, Your Honor?
If we can't handle those matters and those tickets that's on that case under that name, then that's fine. But it's going to be as if you didn't appear for court today because I have.
Ma'am, I'm here today, ma'am.
Right. So I'm just saying when
Williams L is here today. I'm just letting you know who I am, ma'am. Yes, I do. Okay. I am Williams L.
So that's fine. When I call it on the record, I'm going to have to call it on the record as the name on the ticket, just so you know, okay?
Okay, and I'm going to let you know that I'm Williams L. Okay, I'm cool with that. And I'm letting you know who I am. I'm a Moorish American.
Okay. Did you want to offer? Okay. Did you want to offer for it or no? Are you going to try and I need to kind of know where you're going. Are you going to want a trial? Are you going to try and want to?
No, I do not agree. I do not agree to none of this. I'm sovereign.
Okay, so if you're not going to participate, we're just going to act like you're not here today, and I'm going to go ahead and.
I am here today, ma'am. You seeing me right here? That's on record.
Listen, just because you show up doesn't mean that you're here. You have to participate, okay?
Ma'am, I'm a sovereign. I'm letting you know who I am. Listen, I'm participating. I do not agree.
Mr. Williams, that's fine, but if you don't participate, saying you're a sovereign doesn't help me.
I'm just letting you know who I am. That's violating the constitutional right, ma'am.
So do you want an offer or not? That's my question.
Do I want a what?
An offer to the tickets or not?
Do I want to, I can't understand. You said, do I want to offer?
Do you want an offer? Do you want to try and resolve this today as far as?
Yes, I do want to resolve it. I asked for this case to be dismissed off lack of jurisdiction, Your Honor.
Oh, no, that's not going to happen. So you can, I'm not going
to. I'm speaking for myself. I have no attorney, so I'm speaking for myself. I asked for this case to be dismissed. Violated my constitutional right.
How do you have constitutional rights if you're not a citizen?
I'm not a United States citizen.
So how are you entitled to constitutional rights of citizens?
You got to uphold to the sovereign, sir. You can't. I'm not United States citizen. I'm not Negro, Black, or color. You're not under my. I'm not under your jurisdiction.
I understand, but My question to you is, if you want to rely on your constitutional rights, how do you have constitutional rights if you're denying your citizenship?
Because I'm an American. I'm a national.
I get
I'm
it,
a
but
Morse American. I'm not United States citizen corporate. I'm a Morse American. I'm an American national.
okay, but you're still present in this jurisdiction, right?
I just asked for this case to be dismissed off lack of jurisdiction. That's it. I don't want no attorney. I can speak for myself. I'm not a minority. What am I doing here?
He can represent himself. Don't worry about it. You put
I can
yourself on
speak
hold.
for myself.
All right.
I'm speaking
Now
for
calling the
myself.
matters
Y'all
of the
violating my
people.
rights. That's a
Now
sovereign.
calling the matters of the people versus Michael Williams. This is ticket number SP 1212334. Count 1, use loudspeaker without permission or unreasonable noise. Count 2, drove while license suspended. Count 3, no insurance misdemeanor. Sir, please state your name for the record.
I am Williams L.
All right. Sir,
I don't have a name. I have a title.
This is the date and time set for an arraignment on a bench warrant. Do you want to participate in these proceedings?
Yes, I'm here on special appearance. I'm just letting you know who I am.
All right. So how would you like to move forward with this matter, sir?
I asked for this case to be dismissed off lack of jurisdiction, Your Honor.
All right. That motion has been denied. How would you like to move forward on these matters?
I just told you what I would like it, so I don't know. I'm just here on
So it's
special
been
appearance.
denied. So you can either participate today.
I am participating. I'm here.
No.
I'm speaking for myself. I have no attorney, so I'm just letting you know. It's denied, so we can keep going on with proceedings. I am Williams L. I'm not a United States citizen. I'm not Negro, Black, or color. I'm not Christian.
All right, Mr. Williams, it appears to the court as I'm making a record that he does not want to participate in these proceedings.
I told you I
like
wanted to
dismiss
participate.
these
I'm just
matters.
letting you know who I am. I told you for the record.
All right, he would like to not participate in these proceedings. He has told me that he is the person known as Williams L. and not the person on these tickets. So he is not appearing on behalf of this person. This person has not made themselves available to the court today as an arraignment on the bench warrant. So these matters will stay in warrant status. Thank you so much. That concludes this hearing. Have a good day, Mr. L. Williams.
Williams L.
Williams L. I'm gonna call the case as is.
Okay.
And then I'll refer to you as Williams L. if you would like, okay? Now calling the matters of the people versus Michael Williams, also known as Williams L. This is ticket number SP 1212334. Count 1, use loudspeaker without permission or unreasonable noise. Count 2, drove while license suspended. And count 3 is no insurance misdemeanor. Sir, can you state your name for the record, please?
Williams L.
Okay. And is there another name that you have?
That's not my name. That's just my title.
Okay. What's your title that you have, sir?
Williams L.
And then is that your name or your title?
My title.
Okay. You don't have a name at all?
No, I'm not Christian.
All right. It's my understanding that you don't want to have an attorney, sir. Is that correct?
Yes, sir.
Now, you know you have the right to have an attorney. These matters are misdemeanor matters, and you have the right to have an attorney on these matters, sir. And it's my understanding, no attorney, okay? So let me advise you of your rights. In these particular matters, the court can, since they are misdemeanors, do either, I think, 90 days on one of these and up to 93 days in jail, or a maximum fine of $500. These are all misdemeanors, so that's the maximum penalty that can be given in any of these matters. You have a right to have a trial, a bench, or a jury trial in any of these matters. A bench trial is a trial before myself as the trier and finder of facts. A jury trial is a trial with 6 members of the city of Detroit who will come in here and hear the same information and make a decision based on it. These are your rights that you have right now. You also have a right to have a pretrial. What that does is that gives you time to think about any offer that may be given to you. At this point in time, there has been an offer extended to you that if you are willing to plead to the no insurance misdemeanor, it will be reduced to an improper place. I set the fine that goes with that. You have a right to, you can also move for a motion. If you know how to file those, you can file a motion as well. So what's your pleasure at this time, sir?
I know I'm under common law. I'm not under statutes or codes or regulations.
So when you drive on any city street in the city of Detroit, any road in the state of Michigan, you now avail yourselves, whether you wanted to or not, to the laws and states and regulations that are governing us. So you may not have wanted to, but you did. So these are your like options at this point in time. If you choose not to, if you were traveling, if you were driving, it's all the same.
I wasn't driving, I was never.
So if you were just in the vehicle as a passenger?
I was parked. And it was harassing. Was
You
never
sure you
driving.
don't want an attorney?
I'm under common law. I can speak for myself. I'm not a minority. I'm a sovereign.
So what option would you like today? Of those that I gave you, sir. You can have.
Ma'am, I'm a sovereign. I can't, I do not consent. I can't. I can't
So here's
consent.
what's gonna happen. So I want to make sure you have all the options. You can't consent to anything. So that means that you don't want to participate in the process. So it's just gonna go back into warrant status. Because you have to pick one of the options, yes.
Ma'am, I'm a sovereign.
And you were in the city of Detroit on a street in a vehicle. And I understand what you just said. That's why I said,
right.
did you want counsel?
I'm not a United States citizen. Nobody have improved jurisdiction. I'm under common law. Statutes don't apply to me. I'm under common law. Supreme Court case, Supreme Court case, Self versus Ray. Statutes don't apply to me. I'm on common law. And if there was a crime committed, can you please show me the injured party? Or I ask for this case to be dismissed off like a jurisdiction.
I deny the motion for the case to be dismissed, so you have these options, or else it's just gonna remain.
And I'm under duress because you forcing me saying you're gonna put a warrant out for my arrest.
It's already out there.
But that's violating my 13th Amendment. You can't enslave me unless a crime is being committed.
So you can't.
You can't violate my constitutional
Let me
rights.
finish talking. You can't claim you're sovereign and then claim rights under the Constitution. That's not how it works. No, that is not how it works.
I'm not a United States citizen. I have a nationality.
Okay, so that means that
you have to go by
either the laws all apply or none of them apply.
The laws do apply. What do you have a liability? Do you have a bond? Did you swear oath to the Constitution? I would like to see that.
Yes, I was gonna say I did do that, but I don't have to show you any of that because I wasn't the arresting party. I'm just here to
say, do you have a liability? Do you have a bond?
I'm not gonna argue with you, Mr.
I'm not arguing. I'm under law.
Mr. Williams L. Those are your options. If you don't want any of those options, it's gonna remain in warrant status.
You're forcing me. You can't do that.
Okay.
You can't do that, man. You can't go against Constitution.
Okay, Mr.
You took an oath.
Williams L.
You swore an oath to follow the Constitution.
I did.
That's why I need your liability bond. Do you have a liability bond?
No.
You don't have a liability bond?
No.
Wow, man, somebody's gonna get in trouble. I'm not trying to get nobody in trouble.
Yep. Okay.
Okay.
Mr. Williams L., I was gonna say, if you don't want any of those options, then your only other option is that I have to leave it in warrant status.
I do not consent. I'm here. What warrant? That I didn't show up?
That you didn't want to choose one of these things?
I don't have to. You can't force me to do that, all right?
You're right.
You can't force me. You can't put a warrant out. I would like to talk to somebody, a chief judge. You're violating my constitutional rights.
You can go to the fifth floor and make a complaint.
That's because you're violating my constitutional rights.
All right.
And I'm gonna ask the sheriff for your liability bond.
Okay.
Hey, I don't want to do that. I just
you can ask him. Go ahead and ask the sheriff for my liability bond. It's fine.
You took an oath to swear to the Constitution. You took an oath. I'm under common law. I'm not under statutes or regulations.
Okay. Thank you, Mr. Did you get all that, Miss Sandy? Okay, fantastic. All right, that concludes this hearing. Thank you so much.
I'm not Negro, black, or color for the record.
Okay. He said he's not black or color for the record either, okay?
No, I'm Moorish American. I'm a Moorish.
Moorish American, and he's a sovereign.
I have a nationality.
I'm not threatening you. Say one more word and that's 30 days. 30 days.